this slide, we were here. What are the instances when a solicitation or presentation of securities for sale is presumed to be a public offering? When do we presume that an offering of securities is a public one? Okay. So here are the elements that would make it public. There has been publication in a newspaper, magazine, or printed reading material, which is distributed within the Philippines. So publication plus distribution. Then there is presentation in any public or commercial place. Case that would make it public. We also have advertisements or announcements on radio, TV, telephone, or telephone communications, distribution or making available flyers. We have your brochures or any offering material in public place to prospective purchasers. So simply making it known to the public, okay, that you are offering for sale particular securities. It's already making it as public offering. What about private offering? What is private offering? It would refer to sale of securities to a limited number of subscribers by the issuer himself. Look at the criteria that would make it private: limited number of subscribers by the issuer himself. From later on, from the slides on exempted transactions, you will actually determine what we mean by limited number of subscribers that would make it exempt. Okay. So distinguish public offering versus private offering. Public offering involves the general public that has little or no knowledge about the securities offered to them, which is why SEC registration and approval are necessary. Private offering, on the other hand, involves few subscribers who may well be familiar with the securities offered to them. Okay. So there is less tendency to be actually deceived by the offering. What SEC may do to ensure proper compliance with the laws: there is a must requirement for registration of not only the securities, not only the market participants, but also of the stock exchanges. So here, three items that must undergo registration. So if you are a market participant dealing with securities, you don't only register your entity, but also that of the securities that you are offering to the public. Okay. As to the provider of the facility, okay, then stock exchanges too are obligated under the law to have themselves itself registered. So I'm referring to the Philippine Stock Exchange. Regulatory control as exercised by the SEC. We have here registration of market participants. Requires registration of those who participate in the offer and sale of securities, like we have here the different market participants, brokers, dealers, and salesmen in securities exchanges. Another way of the SEC exercising its regulatory control is by virtue of this requirement for full material disclosure. What do you mean again by full material disclosure? What does it cover? All companies listed or applying for listing are required to divulge faithfully and accurately all material information about themselves and the securities they sell for the protection of the investing public and under pain of administrative, criminal, and civil sanctions. So not complying with this mandatory requirement, the consequence of each will actually be to submit the violator to administrative, criminal, and civil sanctions. What SEC may do: may issue a stop order suspending the effectiveness of any registration statement which is found to include any untrue statement of a material fact, or to omit to state any material fact required to be stated therein. So it's not simply a case of having the securities or the entity registered, but being able to actually inform the public accurately of information, material information about the securities it's offering. When is a fact considered to be material? Okay. This is the test of materiality under the SRC. A fact is deemed material if it tends to induce or otherwise affect sale or purchase of its securities. The price of the security is material. The power that it has is material. Okay. So examples of what to disclose: all information relevant to such securities so that the prospective investor may be made aware of their potentials or merits before he invests. Essentially, the contents of a sworn registration, including such information as the names of the directors, officers, general character of the business, the capital structure, prospectus, financial statements, the purpose for which the funds from the security will be used, principal stockholders who own 10% or more, estimated net proceeds, as well as the price at which it is offered to the public. These are all material information. The general rule on the matter of registration of securities. The sale, let us repeat again the rule, the sale or offer for sale of any security in the Philippines should be registered and permitted by the SEC. Exception to the requirement of registration, we have two classes. We have exempt securities, and we have the next class of exemption, securities sold in exempt transactions. So it's not the securities that are exempted, but rather the fact that they are subject matter of a particular transaction. So class 2 of exemptions would be relative, to depend on who the participants are and the nature of the transaction. We have here another slide to actually illustrate or show to us the rule. We have the general rule on the registration of securities and the exceptions under the law. Section 9 on exempt securities and Section 10 on exempt transactions. So we have here corporations trading securities. How is it regulated? By the SEC, by the enforcement of that rule on the mandatory registration of securities before such securities are offered for sale. Securities shall not again be sold or offered for sale or distribution within the Philippines without registration statement duly filed with, and then this registration statement should be approved by the SEC, and prior to such sale, information on the securities in such form and with such substance as the SEC may prescribe shall be made available to each prospective purchaser in the form of prospectus. A would refer to the requirement of an approved registration statement, and B would refer to a prospectus, same prospectus attached to the registration statement. So this is a review of the registration procedures that is implemented and has to be complied with by the applicant on the matter of registration of securities. We have here the filing of a sworn registration. We have here the payment of filing fee, publication that states that all papers relating to such security proposed is open to the public once a week for 2 consecutive weeks. Technically, this is a public offering because we see here publication, notification to the public, SEC approval, which is communicated to the exchange. We're referring to the Philippine Stock Exchange. Then there's again a publication at the expense of the registrant once in a newspaper of general circulation within 10 days of the promulgation or the approval by the SEC of the registration statement. Okay. In approving the registration of the securities, the SEC is not only concerned with the requirement that full disclosure of information is given to the public. The SEC is also concerned with the merit of the securities themselves and the issuer. There is no assurance on the part of the SEC that the securities presented are valid and good for investors. However, there is a penal sanction in case that the securities are not what they were disclosed to be. Okay. Approval of the registration statement by the SEC is not an assurance that the securities, investing in such securities is profitable. Okay? So the attestation of the SEC is not on the profitability of the securities, but rather that same securities have been registered and that the investing public may be assured of a certain level of protection from the SEC. What's the rationale behind exempting some securities from registration? Usually those where there is little risk of fraud on the investor, such as when the amount is small or the offering is only to a limited number of persons. Hence, the SEC deems its registration unnecessary for the public interest. Examples are those guaranteed by the Philippine government or foreign governments with whom the Philippines have diplomatic relations. We have pre-incorporation subscriptions. We have isolated transfers. We have stock dividends, transfers in connection to consolidation or merger. Okay, so these would refer to exempted securities from registration. Again, limited character of the offering, because it's mandated by law that it should be exempted. Stock dividends declared by the corporation because of the protection that the stock dividends declaration enjoys, still within the ambit of the issuing corporation. With its stockholders, there already exists a pre-existing relationship. Transaction is such that the registration of the securities is unwarranted. Okay, so examples that do not need registration, let's list it down. The securities issued or guaranteed by the government of the Philippines. We have here issued or guaranteed by government of any country with which the Philippines has diplomatic relationship or where there is reciprocity. We have here certificates issued by a receiver or trustee in bankruptcy, duly approved by the proper adjudicatory body. So as to the parties that are affected by these issued certificates, it's limited to the parties that are involved in receivership or in trustee relationships. Securities issued by a bank except its own shares of stocks, again covered by a government agency under a special law. Securities or its derivatives whose sale or transfer is under the supervision and regulation of the Insurance Commission, the HLURB, or the BIR. To add to our enumerations under the SRC, under the 2015 rules, we have here number 6, also an exempt security. Any security issued or guaranteed by multilateral financial entities, MFEs, established through a treaty or any other binding agreement to which the Philippines is a party to or subsequently becomes a member. Exempt securities then. Let's take a look at the second classification of those that are exempted from registration. Securities that are covered by exempt transactions did not be registered and approved. What are they? Our listing here will be quite long. Let us take a look at the rationale behind the exemptions. Number 1, at any judicial sale or sale by an executor or administrator or guardian, receiver, or trustee in insolvency or bankruptcy. We have distribution of securities of securities by a corporation actively engaged in business as stock dividend or other distribution out of surplus. We have sale of capital stock of a corporation to its own stockholders exclusively, where no commission or other remuneration is paid. Brokers' transactions executed upon customers' orders on any registered exchange or other trading market. We have sale of capital stock of a corporation to its own stockholders exclusively, where no commission or other remuneration is paid or given directly or indirectly. We have issuance of secured bonds or notes, where entire mortgage together with all the bonds or notes secured thereby are sold to a single purchaser, the single sale. isolated transaction, issuance and delivery of security in exchange for any other security of the same issuer pursuant to the right of conversion, provided that the security so surrendered has been registered or was when sold exempt from registration. Brokers' transactions executed upon the customer's orders, not those made upon broker's solicitation thereof. Also have share subscriptions prior to incorporation or in pursuance of an increase in its authorized capital stock when no expense is incurred or no commission, compensation, or remuneration is paid or given in connection with the sale or the distribution of such shares of stocks. So this technically talks about transactions between the corporation and the stockholders themselves. Exchange of securities by the issuer with its existing security holders exclusively, where no commission and other remuneration is paid or given directly or indirectly for soliciting such exchange. We have this, take note of number 11, sale by issuer to fewer than 20 persons in the Philippines during any 12-month period. We have sale to any of the following qualified buyers. Take note who are the qualified buyers. Letter A, banks. B, investment houses. C, insurance companies. D, pension fund or retirement plan maintained by the government or any political subdivision thereof or managed by a banking institution. Now, E, investment company is also a qualified buyer, another qualified buyer. Such other person as the SEC may, by rule, determine as qualified buyers on the basis of such factors as financial sophistication, net worth, knowledge, and experience in financial and business matters, or amount of assets under management. Another inclusion in our listing of exempt transactions, public offerings that have a limited character as an exempt transaction subject to compliance with various requirements. So this is not automatic. There has to be compliance with additional requirements. So for a public offering to be considered of limited character, the covered securities should be available only to the parties or persons named in the application for exemption for a specified period. Okay, so those would actually make the offering of a limited character. Such limited character, they will be exempted from the requirement of registration. The issuer is also required to submit, among others, a list of the persons and their corresponding positions in whose favor such grant or issuance of options is to be made, indicating the number of shares to be given to each, or if this could not yet be ascertained, the formula to be used in determining the number of shares and the issue price. The securities issued pursuant to an employee stock option plan by a corporation to its employees would fall under this category. So, employee stock option plan in favor of employees, exempt transaction, not needing prior registration. Okay. Here is a requirement for a formal application for exemption. Take note of our rules on construction. So if we are seeking for an exemption, it's not really automatic. There has to be compliance, as we have mentioned, of certain requirements under the law, such as the requirement to obtain formal application for exemption. So any person applying for an exemption shall file with the SEC a notice identifying the exemption relied upon. Is it exempt securities? Is it exempt transaction? If it is exempt securities, what in 1 to 6? If it is exempt transaction, what in 1 to 13? Okay? So relied upon on such form and at such time as the SEC by rule may prescribe, and with such notice shall pay to the SEC, there has to be payment of a corresponding fee. And how much is this corresponding fee? 1/10 of 1% of the maximum value aggregate price or issued value of the securities that are supposed to be of exempt. So 1/10 of 1%. Let's take a look at this problem. Wow Corporation sold securities to 21 non-qualified buyers during a 15-month period without registering the securities, okay, before the SEC. Did WOW violate the SRC? Can you please take a look at the facts of the case, determine if this would fall under the general rule of the requirement for mandatory registration, or would it be covered by any of the exemptions? Exempt securities, exempt transaction. Limited character? Not really. Okay, so you have your own answer. Let us check if your answer is correct. Was there violation? Yes. As provided for under the law, security shall not be sold or offered to be sold to the public within the Philippines unless the securities are registered with and approved by the SEC. Public means 20 or more investors. Take a look to a sold to 21 non-qualified. The fact that the securities were sold during a 15-month offering or period is immaterial. However, the sale of securities to less than 20 investors, which is not the case, if done during a 12-month period, is an exempt transaction in the SRC. So we cannot apply any of the exemptions. Here is a case of the application of the general rule. There should have been registration. So these are the SEC rules on stock options. If stock options are given to non-stockholders, directors, officers, or managing groups, there has to be an approval of at least 2/3 of the outstanding capital stock. Plus, in addition to that, ratification, there has to be SEC approval if the stock option plan is reasonable. The corporation must retain or authorize enough of the junior securities, okay, to meet the conversion or stock option when exercised. What is the period to sell securities after obtaining registration? Under the 2003 rules, it should commence within 2 days within which to sell securities which are a registration statement. So start already selling the registered securities within that period. Under the 2015 rules, on the other hand, the rule says it should commence within 10 business days from effectivity of the registration statement and continue until the end of the offering period or until the sale is terminated by the issuer. Okay, so the purpose of that period of time from 2 to 10, okay, is actually to allow issuers more time to raise capital from the public. So the 2015 implementing rules is clear on the rule on when to sell the securities. The registration statement shall be cancelled if the sale is not commenced within 10 business days. Let's now talk about manipulative devices. It would refer to any scheme which will cause an artificial reduction, temporary reduction, or shortage of available shares in the market while falsely showing activity therein. Okay? That will make it a manipulative device. So we have here an example: creating a false or misleading appearance of active trading in any listed security traded in an exchange of any other trading market. So examples of this manipulation of security prices will be in the case of wash sale or pretended sales. What are those manipulative devices and practices on security prices? When there is creation of a false or misleading appearance of active trading in any listed security at the stock exchange or any trading market, to effect alone or with others a series of transactions in securities that raises or depresses their prices or creates active trading to induce the purchase of security, when in truth, there was really no real transactions involving securities. to circulate or to disseminate information that the price of any listed security will or is likely to rise or fall because of manipulative market operation. What's the commonality between 1, 2, 3? The element of fraud, the element that intention to deceive the public. There's no element of truth in it. To make false or misleading statement with respect to any material fact which you knew or had reasonable ground to believe was so false or misleading, to induce purchase or sale of any listed or traded security at the stock exchange. So as to the profile of the market participant, the issuer, when such profile is actually not true, okay, then technically that is a material information and will result to it being considered as a manipulative. To effect alone or with others any series of transactions for the purchase and or sale of any traded activity at the stock exchange for the purpose of pegging, fixing, or stabilizing its price unless otherwise allowed. So here is an enumeration of the different manipulative devices. These are just examples. This is not an exclusive listing. We'll be taking a look at each one of them in the next slides. Marking the clothes, painting the tape, squeezing the float, hype and dumped, improper match orders, boiler room operations, scalping, daisy chain, flipping, short swing, wash sale. Okay, so what is wash sale? It's a manipulative transaction of a security purporting to be a sale when in fact there is no actual change in the beneficial ownership of such security. There really was no actual change in the beneficial ownership. So it involves transactions in which there is no genuine change in actual ownership. It has the effect of distorting market dynamics, affecting now the prices of the securities. It is carried out to either hide paper losses or to inflate paper gains temporarily or to show increased trading volume and raise the financial institutions' ranking in the league tables compiled by the local bond exchange. Okay? So we have this presumption that if the shares or the securities actively trading, that maybe many people are interested to actually be a part of that entity issuing the security. If this was actually done, okay, erroneously or with the intention to deceive the public, then it's a manipulative device. Because of this, many wash trades are executed toward the end of reporting periods, like the end of the month or the end of the quarter, or maybe the end of the year. So be wary of wash sales. What are match orders? Match orders, by entering an order or orders for the purchase or sale of such security, with the knowledge that a simultaneous order or orders of substantially the same size, time, and price for the sale or purchase of any security has or will be entered by or for the same or different parties. Matching the order with a delivery. Okay? Matching purchases and sale. Are all match orders considered to be a manipulative device? We have to qualify. Okay? So it becomes improper if it was engaging in transactions where both the buy and sell orders are altered or entered at the same time with the same price and quantity by different but colluding parties. When it is open to collusion, so as to just indicate maybe that there is active trading in that particular securities, then it is improperly matched orders. We have an example under the SRC rule of an improper match orders. We have here investor A instructs the broker to buy certain securities at a given price, knowing that investor B has also instructed her broker to sell the same kind of securities at the same price. Okay, improperly matched order. Another characteristic of an improperly matched order is that there really has been no arm's length transaction in the parties where they were able to actually negotiate the price. If that happens, then improperly matched orders. Okay, presumption anyway. What about market trading? Another name is jiggling. By performing similar acts where there is no change in beneficial ownership, similar to wash sale. Painting the tape, engaging in a series of transactions that are reported publicly to give the impression of activity or to give the impression of price movement in a security. Painting the tape, marking the close, buying and selling securities at the close of the market in an effort to alter the closing price of the security. So similar to the concept of window dressing in accounting. Okay. You also have hype and dump, engaging in buying activity at increasingly higher prices and then selling the securities in the market at higher prices. We also have squeezing the float, taking advantage of a shortage of securities in the market by controlling demand side and exploiting market congestion during such shortages in a way as to create artificial prices. This is a similar to a market concept. Okay, it fills my mind. Hoarding, similar to the concept of hoarding. We also have boiler room operations. Well-organized operation where in a room there will be well-trained salesmen operating over several phones and using high-pressure sales talk to get investors to invest in securities offered. It gives the appearance of an active trading, boiler room operations. Scalping, where a person, like an investment advisor, purchases securities for his own account before recommending that security, and then sells the share at a profit upon the rise in the market price following the recommendation. That's scalping. So this is the similar concept to that, you buying tickets of a popular artist, and then when right before the concert begins, you are at the gate, at the entrance, selling the same ticket to viewers at now higher the price. Scalpers. Flipping. It's operated where one office buys a particular stock for customers when another office simultaneously recommends that its customers sell the stock, with the stock being shifted from one office to another, and the firm makes a profit and the brokers earn their commission. So sila din internally. So imagine that this is actually a firm, has different offices. Okay? But then again, there is collusion between the two offices. The reason why there is also a requirement under the SRC for the creation of Chinese walls in certain entities, so as to avoid the sharing of information to the advantage or to the disadvantage of the party. Yan yung Chinese wall, sinasabi natin under the SRC. There has to be Chinese walls. Earning. It involves the excessive trading by a broker-dealer in a customer's account with a view to generating commissions. Okay? It might actually involve the same parties, but here comes the broker-dealer, okay, engaging in excessive trading with the same party involved. So katatapos mo palang mag-purchase ng isang batch na securities, here comes your broker-dealer, another, again, engaging in that same kind of transaction with you. Okay? Churning. Again, it becomes a manipulative device because there exists abuse and there exists falsity or fraud, the intent to deceive. What about short sale? What do we mean by a short sale? Are all short sales prohibited? It includes the following elements. It would refer to any sale of a security which the seller does not own. What was sold was a security that the seller does not own. Come to think of it, you might be thinking about your contract of sales that with this alone, there has been a violation of the principle on the law and sales, because what matters is that at the time of the delivery, the seller has that ability to transfer ownership, yes, but here is the second element. Any sale which is consummated by the delivery of a security borrowed by or for the account of the seller with the commitment of the seller or securities borrower to return or deliver said securities or their equivalent to the lender at a future time. So the element of fraud that is attempted to be penalized, okay, under an unlawful short sale is you obtaining profits from the property of another person, and there is an element of abuse by virtue of the relationship that exists. Short sale. There is no absolute prohibition. Exception. When does it become prohibited? When does it become unlawful? Short sales and securities of the corporation made by directors. Take a look at the people involved. Directors, officers of the principal shareholder of such corporation. Whenever the SEC, motu proprio, or own its own, or upon recommendation of the exchange, prohibits short selling. Another kind of sale. Sale against the box. What is this sale against the box? When a seller anticipates a decline in the price of stock he owns, he will sell it to the buyer at the present market value, but deliver it later when hopefully the market price will have fallen below the sales price, thus creating a paper profit for the seller. So there is here an unauthorized delay in the delivery, okay, so as to actually profit from the time. Okay, and po yung sale against the box. Let's go back to short swing. What's the short swing's profit rule? Any profit realized by insiders of an issuer from the purchase and sale or any sale and purchase of any equity security of the issuer within any period of less than 6 months, unless such security was acquired in good faith in connection with the debt previously contracted, shall inure to and be recoverable by the issuer. Okay, so what would make this rule applicable, or when should we apply the rule? You take a look at who the parties are. When was this particular transaction? When did it happen? When did it transpire? Okay, so pag nakita nyo na po, isa checklist niyo, all the elements are present, then the consequence of such would be what? Okay, the profit says will have to inure, okay, to and be recoverable by the issuer. So the corporation that is represented by these insiders. So separate and distinct from the insider trading rule, the short swing profits rule, remember this, is different from the insider trading rule. The effect of the insider trading, it was entered into by insiders, but that would not make short swing profits rule the same as insider trading. Okay? Tingnan natin mamaya, ano po yung insider trading. The short swing profits rule is not intended to prohibit the named insiders from transacting and earning profits, but however, it was put in place, this rule, to prevent them from unfairly using and benefiting from information that may have been obtained by them by reason of the relationship with the issuer and in order to ensure a fair and honest market. Ganyan ka-importante po yung i-establish natin kung sino po yung mga parties na nag-engage sa activity na to at the period. Okay? So, a short swing profits rule is considered to be a rule of strict liability by the mere presence of all the elements as we have seen in the definition. The rule will have to be applied to avoid, to prevent the possibility of insider trading. Ano po yung rule natin? Ano yung consequence? That the profit should now inure back to the issuer. Okay, and make the person, the insider here, liable for damages plus interest. Neither intent nor actual use of the inside information is required. All that is required is that profit was made from a combined purchase and sale of equity securities within a period of 6 months by the insiders in question. Okay. An action to recover such short swing profits may be instituted before the RTC by the issuer or by the owner of any security of the issuer in the name and in behalf of the issuer, if the issuer shall fail or refuse to bring such suit within 60 days after request, or shall fail diligently to prosecute the same thereafter. So prosecution is different from commencing to file a case. Okay, case might have been, the case to actually collect might have been initiated, but if it was not prosecuted, then still we have to, there are remedies under this particular rule. The collection suit should be brought within 2 years from the date the profit was realized. So what is the effect? If the action was brought now beyond the 2-year period, then we say that the right has prescribed, and prescription now, okay, will extinguish that right and the corollary obligation of the other party. Short swing profits rule. Short swing profit is prohibited under the SRC, and an action may be filed against such director, officer, principal, stockholder. The action belongs to the issuer company to prevent unfair use of information as a general rule. But then this previous slide would also talk about the possibility of the owner of the security of the issuer filing that case. Yes? And derivative suit po yung concept. So, still on short swing profits rule, the elements to maintain the action, it must involve an equity security, not debt, not instrument, not derivative. Okay, there should be matching sale and purchase of, or purchase and sale. There should be purchase at a low price, bought back at another lower price. The company or the issuer must bring the action subject to a 2-year prescription period from the date the profit is realized. So here is a question. What are those unlawful acts with respect to the purchase and to the sale of securities? Number 1, the employment of any device, scheme, or artifice to defraud. Okay. When a person engages in any act which operates as fraud or deceit upon any person, obtain money or property by means of any untrue statement of a material fact, or any omission to state a material fact necessary in order to make the statements made not misleading. Let us highlight certain rules on the matter of protection of investors. Okay, our investors are again protected. This is simply a recall so that we will not forget. The law requires full disclosure of information to the public regarding the securities that are being offered and the issuers, including the filing of and the approval of the registration statements and the approval of the prospectus. Number 2, there is a continuing duty to regularly submit material information to the SEC. So this is consonance also with the requirement of the SEC for the submission of periodic reports, quarterly reports, we have annual reports, and many other kind of reports. There is supposed to be close monitoring of the securities and other circumstances that may affect the same as well as the persons involved. You have prohibiting and penalizing different fraudulent practices and transactions too. The sale of securities becomes unlawful, shall be unlawful if the person selling security or his principal does not own the security sold, short swing. If owning the security does not deliver it against such sale within this number of days, or does not within 5 days after such sale deposit it in the mails or other usual channels of transportation. The prohibition, however, does not apply to a dealer in the ordinary course of his business and incident to the establishment or maintenance by him of a primary or secondary market otherwise than in an exchange for such security. Let us now take a look at another instrument, another facility, another activity, another arrangement that is required under the law, tender offer. And I guess you heard me mention this Okay, another topic on mergers and acquisitions, on the matter of how do we protect the right of minority stockholders. Okay, so what again is tender offer? Means a publicly announced intention by a person acting alone or in concert with other persons to acquire equity securities of a public company. I declare that I would like now to buy equity securities of a certain public company. Its purpose is to protect minority shareholders against any scheme that dilutes the share value of their investments. Would it dilute the share value of the investments if they would, I'm referring to existing shareholders, if they would be denied of that right to exercise their right of preemption, then technically it will dilute, okay, their company power. There are two kinds of tender offer. It could be a direct acquisition, or it could refer to an indirect acquisition, still governed by the rules. So, paano po yung direct acquisition? Okay, if what is intended to be purchased would refer to the outstanding equity shares of a public company, or if not, okay, the outstanding equity securities of an associate or a related company of such public company which controls said public company, then that is a case of indirect acquisition. Direct or indirect, in certain situations, okay, making tender of offer is really mandatory under the law. What would make it now mandatory? Okay, so we're talking about what would make it tender offer. Why? Okay, why is there tender offer rule? To prevent the stockholders of the target company from being misled by the offeror or the target's management. This, thus, the principal requirement of the SEC rules on tender offers is to disclose by the offeror certain information about the offer, with a copy of such information being given or sent to the stockholders. So, yeah. To protect the minority stockholders versus any scheme that would dilute the share value of their investments, would give them the chance to exit, okay, the public company under reasonable terms, giving them opportunity to sell their shares at the same price as those of the majority shareholders. Because it may happen that the person intending to now acquire company shares would be a person that existing shareholders would not wish to get themselves affiliated with. That may actually happen. So we give the opportunity for these existing shareholders to exit the corporation. So this is another reason for tender offer. We have here an example, an illustration, and the issue raised in this particular case would be whether or not the group of First Pacific should be required to make a tender offer to shareholders of Manila Electric. To our mind, okay, the person, that party that would wish to exercise its right to sell or to buy, there's a right to purchase equity shares would be First Pacific, okay? And what it is now attempting to purchase from will be Manila Electric. Metro Pacific signed an agreement with First Philippine Holdings for the acquisition of approximately 0.7% stake in Meralco in the form of a call option that can be exercised at any time from the date that the call option is granted until the end of this particular period. Once the call option is exercised, we have here MPIC and Filipino Telephone Corporation subsidiary. So this is an indirect acquisition. Okay, if it will be exercised, it will now own about 41% of Meralco, above the 35% tender offer threshold. But if it will purchase into the corporation, that will now make it obtain this much power. Okay, so SEC in this particular problem has jurisdiction to enforce the SRC tender offer provisions and its implementing rules and regulations. What are the elements that are present that would trigger the imposition or the application of the tender offer. So it's a similar case involving this particular case. Yes. So let's take a look at the requirements under the 2003 rules, mandatory tender offer. Okay. Again, we're just repeating from our discussion from mergers and acquisitions. Any person or group of persons acting in concert who intended to acquire, there is an intention to acquire this much shares in a public company, okay, they were required to disclose such intention and make the tender offer. Sometimes, when we try to actually solve problems like this, the first thing that we need to do is whether the company that is attempted to buy from is determine if it is a public, is it publicly listed, would it fall under the second test? Does it have assets this much? Okay, and does it have stockholders holding this much? Okay, yun po yung test ng mandatory company. So yung definition natin ng public company, hindi po yan walang saysay. We can actually make use of that as a test whether we could apply certain rules that are found under the SRC. Under the 2015 rules, there are additional rules now with the intentions that are only 15% of the equity securities in a public company in one or more transactions within a 12-month period. Okay. Said person or persons only need to file with the SEC a declaration to that effect. So it does not need to make that tender offer. Okay. What it needs to do is to inform, okay, to disclose that intention to the SEC. The rules allow two levels of action depending on the percentage of equity shares intended to be acquired. Is it initial acquisition or would it be the crippling acquisition rule, as I have explained in the previous one? And in 35% po, ano na po ngayon, of the outstanding voting shares must have that voting power. Okay? Yan po yan. Okay. Not new, you know this. Guidelines have been set for accredited firms regarding the conduct evaluation and the issuance of fairness opinions in relation to tender offers, or things that are put in place under the SRC rules. Conduct an evaluation, issuance of fairness opinions. The individual who acts on behalf of the accredited firm shall also be a licensed professional who has at least 10 years of experience in the field of accounting, finance, or economics, and holds a relevant advanced degree. That's the reason why, take note, if you are really, segue muna tayo, if you are to take a look at the jobs that would pay more in the Philippines, listed po yung mga people with this business acumen, okay? And those with knowledge about securities and dealings with securities. What is the fairness opinion report? It shall be signed by the firm's representative of a rank not lower than a partner or a VP or their equivalent respectively. He shall indicate his complete name, he has the professional license number, TIN, firm name and address, and PSE accreditation number of the firm, if any, and other technical information. Fairness opinion report. These requirements are laid out to ensure the proper and the accurate valuation of securities offered to the public for the protection of investors. Bias report po yan, kasi third party. Securities deposited may be withdrawn at any time throughout the period that the tender offer remains open. And if deposited, will there be securities deposited have not yet been previously accepted for payment and at any time after 60 days from the date of the original tender offer or request or invitation. Time period by which securities may have been withdrawn. Okay. Other tender offer highlights. When is it mandatory? When do we presume that the tender offer is not mandatory but simply voluntary? Unlawful and prohibited acts relating to tender offers, the making of an untrue statement of a material fact, or omitting to state any material fact in order to make the statements made, not misleading. That's the purpose of the requirement. Okay. Another prohibited act, engage in any fraudulent, deceptive, or manipulative act or practices. The SEC may exempt a person from the mandatory tender offer requirement under what conditions? On proposed purchases of equity shares of a public company of newly issued shares from unissued capital stock. So technically, this would be what subscriptions contract in connection with foreclosure proceedings involving a duly constituted pledge or security arrangement where the acquisition is made by the debtor or the creditor. In connection with privatization undertaken by the government, in connection with court-supervised corporate rehabilitation. So, pwedeng exempted po yan sa mandatory tender offer. Okay? Exempted siya, pero ginawa pa rin yung tender offer, then technically what was actually done is not mandatory tender offer, but voluntary tender offer. Okay? So we strictly apply the rule, okay, in a case of a mandatory tender offer, not in a case of voluntary tender. What is the Swiss challenge? Okay, so under the Swiss challenge format, one of the bidders is given the option or preferential right to make the winning bid. So technically, there is collusion. Okay? Kunya-kunyari lang yung pagkakaroon ng bid para lang masabi na the procedures required under the law has been complied with. Okay? Swiss challenge. In the matter of government projects with unsolicited bid, the government invites private groups to make competing offers while giving the original proponent the right to match them. A form of public procurement which requires a public authority, usually an agency of the government, which has received an unsolicited bid for a public project or services to be provided to the government, to publish the bid and invite third parties to match or exceed it. Okay? So, meron kaming unsolicited bid, hindi kami mismo ang humingi na mag-bid siya. Okay, we're informing the public, we're publishing it, and we're inviting third parties to actually match or even exceed it. Yan po yung Swiss challenge application. As you're imagining the telco situation in the Philippines, there could have been Swiss challenge application in that case. Under current BOT, BOT would refer to build, operate, transfer, and procurement laws. Not all projects, particularly in cases of priority projects, can be implemented via the Swiss challenge application. Okay? There are programs that should not undergo bidding. May mga negotiated sales, and po yan, under BOT. So that's tender offer. Take a look at insider trading and what insider trading, when is it considered to be fraudulent. Insider trading would refer to the illegal buying and selling of stocks on the basis of information that is generally unavailable, not available to the public. Okay. When someone sells or buys a security while in possession of material information with respect to the issuer or the security that is not generally available to the public, which he gained from his insider relationship and which he did not disclose to the other party, or he had no reason to believe is in possession of the other. Who are insiders? Okay. Insiders may refer to the issuer himself, or if not, director or officer, or any person performing similar functions of a director or officer of, or a person controlling the issuer. Okay, letter C, gives or gave him access to material information about the issuer or the security that is not generally available to the public. So the source of this insider information, source of the material information. It can also be a government employee, director or officer of an exchange, clearing agency, and or a self-regulatory organization who has access to material information about an issuer or a security that is not generally available to the public yet. Or an insider may also refer to a person who learns of such information by communication from any of the foregoing insiders mentioned in A, B, C, and D. Just look at this. What again is insider trading? This is an attempt to actually re-emerge the elements of insider trading. Okay, the act. Okay, who did the act when in possession of material information with respect to the issuer or the security that is not generally available to the public? The unless clause would refer to exceptions to the general rule, meaning if you are able to obtain, able to actually prove, the presence of these things, then it's not insider trading that is prohibited. When the insider proves that the information was not gained from such relationship, okay, so there is no abuse of the relationship, abuse of authority to obtain that information, or another defense is that if the other party selling to or buying from the insider is identified and the insider proves that he disclosed the information to the other party, or that he had reason to believe that the other party otherwise is also in possession of the information, meaning the information, although material, okay, it's also known. Okay, so hindi po talaga siya kinubling material information. When is a fact material? When is an information material? Similar to a previous slide on the matter, any fact or information that may result in a change in the market price or change in the value of any of the issuer securities or may potentially affect the investment decision of the investor is considered as material. What is not public information? Materiality. So bukod sa materiality ng information, tingnan din natin kung is it public or non-public information. Okay. Non-public, if it has not been generally disclosed to the public and would likely affect the market price of the security after being disseminated to the public, and the lapse of a reasonable time for the market to absorb the information. If it would be considered by a reasonable person important under the circumstances in determining his course of action, whether to buy, whether to sell, or whether to hold on to a security. Yan po. So, there is a presumption to have been affected na merong insider information or insider trading if he was in possession of a material non-public information and he did the following. Okay? That is when the presumption that insider trading happened will actually exist. Rebuttable on the presumption, however, established is rebuttable. Okay? It can be rebutted, can be controverted by evidence to the contrary. Evidence like the information is not material, evidence like the information, the material is actually already public. So here is an example. Our scenario would involve purchase of company equity shares. Who attempts to actually engage in this purchase, an insider. Maybe he is a member of the board of the concerned company. Maybe it is the firm's investment bankers or proxy printers or lawyers, company officers, large stockholders with holdings equivalent to 10% of the company. It may also be employees. It may actually be employees who have direct access to the information that is not yet made public. How was the purchase of the company equity shares done? Okay, making profits in the market on that good information that they have, which has not yet been made public. So this is similar to a case, actual case in 2016 that was decided and banked by the SEC. The SEC slapped Ong Pin with a fine of 174 million pesos for allegedly using insider information to profit from the trading of Philex mining shares in 2009 when the First Pacific Group was still scrambling to gain a controlling stake in the mining firm. First and the only case of insider trading so far decided by the SEC and bank under the SRC. Okay, so the SEC said Ongpin was liable for 174 counts of insider trading in violation of the SRC. It slapped the maximum fine of 1 million for each of the 174 transactions. The questioned transactions pertained to Ongpin's purchase of additional shares of Philex ahead of a December 1, 2009 private agreement he had entered into with Pangilinan during that time. And during then, Ongpin was able to consolidate the required number of shares, supplementing its block of shares with the shares brought from the open market and sold them to the subsidiary of First Pacific at a privately agreed price of 21 peso per share, thereafter giving the First Pacific Group control over Philips. The decision reversed an SEC and bank ruling. 2017 decision of the Court of Appeals, it reversed the decision of the SEC and bank. Okay? In July 2016, which prohibited Ongpin from becoming a part of the board of any PSE-listed firm based on a finding of no material information. So despite the first case that should have been decided by the SRC and bank, pagdating po sa korte natin, sa Court of Appeals, binaliktad po. Sabi, hindi po to case na insider trading. Bakit ang defense yung information ay hindi daw material information? Okay? So he remains, we are referring to Ongpin as chairman of this company. So pwedeng mangyari na ang finding ng mismong government agency that should have implemented the law, they are supposed to be experts on that field. They should know very well the elements of insider trading. Yet, here comes now the court, the appellate court, will decide na no, it's not really a case of insider trading. That happened in the case of Ongpin. Take a look at another hypothetical case. J is a director of S Corporation, a company listed in the exchange. So we have here a public company. We have here a director who is indeed an insider. In the board meeting of S Corporation, it was revealed that it discovered a major gold vein, but the information about it was withheld until another group of geologists has verified the findings of the first group of geologists. B, the firstborn son of J, bought shares S Corporation on the day following the said board meeting. Okay? So, ano nangyari sa board meeting? Medyo nagkaalaman. Material information ba yan? Okay? So, it's a question of, is the information material? If it is material, is the information non-public? Okay. Who entered into such transaction? Can he be considered as an insider? Well, those are the things that you should actually take a look at. So the question, is could there have been violation of insider trading? Okay. Suggested answer, yes. As much as B is a relative within the second degree of the director who is an insider with knowledge of a material information not available to the public, B is presumed to have knowledge of such information also. Hence, his act of buying shares of S Corporation is unlawful, having been made while in possession of material information with respect to S Corporation that is not generally available to the public. Convinced that the information is material, would the discovery that there exists a vein or mineral vein be material? Of course, it is material. Knowledge of it will actually result to the price of the security shooting up. However, this presumption of knowledge of information may be rebutted upon a showing by B, so there is a defense that he was not aware of the material non-public information at the time of the purchase. So the fact that he is an insider would not make him already liable for insider trading. Okay, the defense will be that the information is not material, that the information, although material, is not public, or it could be because it should not be considered both as material or non-public. Pwedeng sabihin natin na pwedeng material siya, pwedeng non-public siya, pero he himself as an insider, did not know about it. Okay? Well, those are possible defenses. Another problem, the directors of a mining corporation purchase shares. Let's continue. Directors of a mining corporation purchased shares in the corporation. Later, they were apprised of an important discovery in its mining lease. The discovery was published in the newspaper. So may binago tayo dito na relevant fact. It will be the discovery of the mining lease. Yes? Okay. So when did they purchase it? Was it before the information or was it after the information? Okay. They sold their shares at a higher price, higher than the acquisition cost. Can they be made liable for the insider trading? So statement number 2, important in your timeline, to determine whether or not there exists liability for insider trading. In this case, no, they cannot be made liable for insider trading. They acquired their shares in the ordinary course of business and before acquiring information of a fact of significant importance. They never used the information of significant importance to their advantage. Aside therefrom, the information was published in the newspaper and therefore made available to the public, publicly available. This slide, will be all about liabilities for insider trading and insider trading alongside with a tender offer violation. So IT is insider trading, TO is tender offer. Shall be liable in a suit brought by any investor who contemporaneously with the purchase of securities that is subject of the violation purchase securities of the same class unless such insider proves that such investor knew the information or would have purchased at the same price regardless of disclosure of the information in that clause that is actually in blue would be defenses for possible liabilities for insider trading or tender offer. Any insider who communicates material non-public information shall be jointly and severally liable, meaning solidary, and to the same extent as the insider to whom the communication was directed. The person who communicated, the insider who communicated it to the person who obtained the information and profited therefrom. Okay? In liability po dito, treble the damages. An amount not exceeding triple the amount of the transaction that's what we mean by treble damages. Because actual damages, exemplary damages, actor attorney fees not exceeding 30% of the award. Administrative sanctions too, fines, and disqualification from being an officer, member of the BOD. Criminal penalties too, may be fine or imprisonment or both at the discretion of the court. Okay, here is another activity, solicitation. What do we mean by this one? It is the act of seeking or asking for business or information, including the act of providing information about a security or investment product being offered for sale, with the view of making another person a client or closing or bringing in a sale or purchase of security or investment product. Solicitation. The solicitor need not be a signatory to any contract relative to such offer or sale of security. What is proxy solicitation? It means any request for proxy or authorization, any request to execute or not to execute or to revoke a proxy authorization, proxy solicitation. So the proxy here is the proxy that you know under the revised corporation code. Okay? So yung solicitation lang po, it's made as an instrument to actually engage in this particular kind of activities to gain or benefit. So how do we further explain proxy solicitation? This is a process by which an interested party sends out documentation, information statement, and proxy statements, proxy forms to investors to ask to them for their vote on an issue. So parang the proxy is the one asking for appointment. That may be the one to vote for you. Okay, This is an attempt to ensure that they obtain a sufficient number of votes to pass or defeat the initiative during the stockholders meeting. Technically, itong proxy solicitation, usually if you are a fan of Korean telenovela involving a corporate setup, okay, they would actually illustrate, or there will be scenes about this proxy solicitation in order to obtain control or in order to maintain control over a particular corporation. Naisip pa kayo napanood yung Korean novela na ganito po ang setup. Marami, no? So, the stockholder who wishes a third party to vote for him will issue him a proxy statement to be duly verified in accordance with the SEC rules. Okay, so there are different scenarios where proxy solicitation may happen and may be availed of. Okay, so scenario number 1 talks about defeating management initiative. Ano ba yung recommendation ng management that these stockholders would like to defeat? To sell a division of a manufacturing business, to dispose of a business line. So technically, management prerogative, this can happen, but it has to be ratified by the decision of there's a requirement for ratification of the shareholders, because this, in essence, is a substantial corporate action. So what would this group of stockholders do? They would contest the management initiative. How? Okay, they would issue yung mga proxy, they would conduct proxy solicitation so that the recipient stockholder of the solicitation, when in agreement with the proxy initiator, will complete the proxy form indicating that the group, okay, will be allowed to vote for his shares on the issue of the upcoming meeting. So gagamitin yung kanyang boto para ma-obtain yung black. Another scenario would be the other side of that picture. Okay, we have your management or the board recommendation, yung proposed merger. In order to secure the needed vote to pass this proposal by the management, the remedy of the management also is to undergo proxy solicitation. So yung recipient stockholder natin ng proxy, when in agreement with the proxy initiator, in this case, yung management, okay, will complete the proxy form indicating that the management group, be allowed to vote for his shares on the issue at the upcoming meeting. Marami pong pwedeng gumamit ng proxy solicitation yung mga parties to these actions that should be decided along with the ratification of the stockholders. Ano yung rules natin ng proxy solicitation? Proxy solicitation rules applies to a reporting company and to any other person soliciting votes from the stockholders. So when we talk about proxy solicitation, to be technical about it, it's not only applicable to yung ating mga public companies, but also companies that are actually soliciting votes from stockholders. Mas broader po siya sa application yung ating proxy solicitation rules. The proxy rule is done not only in connection with the election of a director, but also with respect to yung mga substantial corporate actions under Section 6 of the SEC, BSIMID. We're talking about the BSIMID. There are additional rules on proxy solicitation. A broker-dealer cannot give a proxy in respect of any security it carries for the account of a customer without express written authorization of such customer. Take note po kung ano yung right na meron si broker-dealer doon sa mga security that is in his hands. Wala po siyang legal title over the same. So there has to be a written express authorization by the one in possession of the legal title. That's essentially the essence of this rule. A broker-dealer who holds or acquires the proxy for at least 10% or such percentage as the SEC may prescribe of the outstanding share of the issuer shall submit a report identifying the beneficial owner within 10 days after such acquisition for its own account or that of the customer, to the issuer of the security to the exchange, or the security is traded, and to the SEC. May reporting po tayo dito na kinakailangan to protect the various parties involved. Another thing, margin trading. Ano po yung margin trading naman? The customer purchases stocks by advancing only a portion of the purchase price with the broker extending credit or making loan for the balance thereof. So parang a shareholder buying shares of stocks, pero as a portion of the consideration is actually paid for by his broker. Nag-extend ng credit yung broker doon sa kanyang customer na margin trading. Okay, is it prohibited? Absolutely. Pwede bang mangyari ito? Yeah, it happens, yes. It may be that the customer is short of the consideration required. Yes? And so, paano ba nangyari sa margin trading? Trading that allows a broker to advance for the customer investor part of the purchase price of the security and to keep it as collateral for such advance. So in the meantime, it would refer to that securities subject matter of the same trading. The credit extended, yung margin allowance standard must be for an amount not greater than whichever is higher of. So basically, may limit po yung pwedeng i-advance ni broker. Okay? At meron din pong time period na dapat ibalik ni stockholder yung in-advance ni broker. This is the margin trading rule. Okay? So take a look at the thresholds. Okay? Ito yung mga thresholds natin. Who has the burden of complying with the margin trading requirements? It is the broker or the dealer's burden. Kasi sila po yung mga may experience, sila po yung may exposure sa markado, okay? And not really the stockholders. So in securities trading, the brokers are essentially the counterparties of the stock transactions at the exchange. Since the principles of the broker are generally undisclosed, the broker is personally liable for the contracts thus made. Brokers have a right to be reimbursed for the sums advanced by them with the expressed or implied authorization of the principal. The requirement for brokers, the imposition of stricter rules upon brokers and dealers is an effort to comply with the Anti-Money Laundering Act. Yung stricter rules po yung ating thresholds dito, so how much they can advance and from what period they should be reimbursed with the amounts that they have, making them liable for violation of that proxy solicitation rules. Margin trading rules, margin trading rules. So other requirements, the brokers and the dealers are not allowed to maintain a numbered account for trading or investment purposes, client or his own account. So, hindi po sila allowed na numbered account. Anonymous accounts under fictitious names, and all other similar accounts shall be absolutely prohibited. The SEC is authorized to conduct effective surveillance and investigation of trade events by requiring brokers to provide them access to particular accounts, orders, trading account codes, and the names of clients corresponding to such code. Okay, so we're done with margin trading, we're done with proxy solicitation, insider trading, tender offer, okay, registration requirements, remedies of investors, okay. For possible violation of any of those we have mentioned a while back, okay, our investor could actually annul the contract or file an action against the broker, the dealer, or the issuer, or file an action against the bond or the trust, if there be bond or trust. Okay, possible courses of action, cases of fraud or violations, pwede pong civil injunctions, so civil remedies, criminal prosecution, criminal remedies, administrative remedies too. Okay, so the choice of one will not actually bar the others. Pwede po ito lahat sabay-sabay. So what is the civil injunction or civil remedy? The SEC may issue an ex parte may issue ex parte on its own a cease and desist order (CDO) for a maximum period of 10 days, enjoining the violation and compelling compliance with the relevant provisions. Okay? So when you enjoin a violation, stop doing prohibited. Okay? Criminal prosecution. The SEC shall refer all violations of the code to the DOJ for preliminary investigation and prosecution before the proper court. Okay? So referral po yung trabaho po dito ng SEC on the matter of violations of the SRC or the RCC. So technically, the one that will conduct preliminary investigation if there indeed existed violation would be DOJ and then prosecute before. Administrative remedies. The SEC may suspend the security from being traded and revoke the registration of the security. The SEC may suspend or revoke the license of the erring broker, dealer, salesman, and associate person or any market participant. Okay. Certain reportorial requirements that are required in relation to the SRC provisions, periodic or other reports of issuers. You have there the annual report, periodic reports, general information sheet, GIS. You have there the due date within 30 calendar days from the date of the actual stockholders or members meeting. Reports by yung mga 5% and more holders of equity securities of particular market participant. Let's take a look at the problem before we end this presentation on SRC. We have Union Bank of the Philippines is a commercial bank listed in the stock exchange and is under the supervision of the Bangko Sentral ng Pilipinas and the Philippine Stock Exchange. Why under the supervision of PSE? Kasi listed. Okay, so SEC adopted the full material disclosure rule, wherein all listed companies are required to submit reports about themselves, profiles, and the securities they sell, prospectus that are necessary for full, fair, and accurate disclosure of the investing public. However, Union Bank contends that since its securities are exempt from registration, yes, indeed, it is exempt from registration, and is subject to BSP supervision, it is not covered by the rule on the submission of reportorial requirements. If we were to decide this case, okay, would the contention of Union Bank be tenable? Is it with merit? Sino ang nasa tama? Okay, what do you think? Are they exempted from the SRC rule on reportorial submissions? Would exemption from one rule also mean exemption from the rest of the rules? Union Bank here is wrong. The exemption enjoyed by Union Bank merely refers to the initial requirement of registration of securities for public offering and not the subsequent filing of various periodic reports. As a corporation trading in securities in the stock market, it is under the supervision of the SEC. So even the PSE is under the control and supervision of the SEC. The fact that in regard to its banking functions, Union Bank is subject to BSP supervision does not exempt it from reasonable SEC disclosure regulations. Yung submission po ng mga GIS, example po yan, hindi po exempted itong mga entities that are actually covered by other government agencies. So that will be all for the presentation. I hope you learned something about the SRC. Okay, I am challenging you to write down, jot down in a journal maybe your takeaways